हेलो दोस्तों, वेलकम टू माय चैनल एडवोकेट सुंबल। और आज की वीडियो में हम बात करेंगे LL.M सेकंड सेमेस्टर के कॉन्स्टिट्यूशनल लॉ के थर्ड पेपर नेशनल सिक्योरिटी एंड पब्लिक ऑर्डर के बारे में। और इसके आज दो यूनिट इसी वीडियो में हम देखेंगे। यूनिट फर्स्ट, नेशनल सिक्योरिटी एंड पब्लिक ऑर्डर कंसेप्ट एंड मीनिंग। नेशनल सिक्योरिटी एंड पब्लिक ऑर्डर आर टू क्रिटिकल concepts related to the safety, stability and sovereignty of a country. Both terms, while interconnected, represent different aspects of governance and law enforcement. They are essential to maintaining peace and ensuring the well-being of citizens. Security concept of national security. National security refers to the protection of a nation's interests, territorial integrity, sovereignty and citizens from both external and internal threats. These threats can come in various forms, including military aggression, terrorism, cyber attack, espionage and even economic instability. It encompasses the overall safety and defense of the nation, ensuring that the state can effectively protect its borders, maintaining internal peace and safeguard its institutions and values. Components of national security. National security is not only about military protection, it includes a broad range of dimensions such as military security, protection from external military threats and aggression, economic security, protection of the country's economic system, infrastructure and resources from threats like economic sabotage or attack on critical industries. Cyber security, protection against cyber threats, hacking and digital espionage. Energy security, ensuring the steady supply and sustainability of vital energy resources like oil, gas and electricity. Environmental security, addressing issues such as climate change and resource depletion that may pose long-term risks to national stability. Social security, protecting citizens from internal social unrest, violence and extremism. National security in India. In India, national security is primarily managed by the Ministry of Defense, Ministry of Home Affairs and National Security Council. Internal security is often dealt with by agencies such as the Central Reserve Police Force, CRPF, Border Security Force, BSF, and the Intelligence Bureau, IB, among others. The Armed Forces, Army, Navy, Air Force ensure external defense and territorial integrity, while internal threats like terrorism, communal violence, and insurgencies are managed by paramilitary forces and law enforcement agencies. Public order. Concept of public order. Public order refers to the state of peace and lawfulness in a society, which is essential for the smooth functioning of the state and its institutions. It is concerned with the maintenance of peace, social stability and prevention of violence with their territory. Public order is concerned with the well-being of citizens and it ensures that individuals or groups do not disturb the formal functioning of society by resorting to violence, public disturbances or threats. Components of public order. Public order encompasses several elements that ensure the social stability and peaceful functioning of society. Law and order, ensuring the maintenance of peace through the rule of law, where citizens adhere to the law and respect public norms. Control of violence, preventing and controlling incidents of violence, riots, strikes, or social unrest. Safety and security of citizens, ensuring that the general public is safe from harm, whether it be from criminal activities or civil disturbances. Civil liberties and rights, balancing public order with the protection of fundamental rights and freedoms of individuals while ensuring that the peace of society is not disturbed. Public order in India. Public order in India is a state subject under entry 1st of list 2nd of the 7th schedule of the Indian Constitution, meaning that states have the military responsibility for maintaining public order. However, the central government can intervene if the situation becomes critical or widespread. The Indian Penal Code (IPC), now BNS, and the Criminal Procedure Code (CRPC), now BNSS, along with specific legislation like the Unlawful Activities Prevention Act (UAPA), provide mechanisms to control disturbances and maintain public order. Police forces and the Central Armed Police Forces (CAPF) play an important role in managing public order, particularly during protests, riots, or other public disturbances. Interrelationship between national security and public order. While national security and public order are distinct concepts, they are often intertwined in practice, as disturbance in public order can sometimes threaten national security and vice versa. For instance, terrorism and insurgencies, a national security threat, often led to violation of public order such as violence, bombings and public disturbances. Communal rights or ethnic conflicts can disrupt both public order and national security, as they can lead to widespread social instability and can even have cross-border implications in the case of external support to insurgent groups. Measures to safeguard national security, such as declaring emergency or imposing military intervention, can affect public order by restricting civil liberties and imposing curfews or movement restrictions. Constitution provisions relating to national security and public order. In India, both national security and public order are addressed by the Constitution and various laws. Article 19, Clause 1, Subclause B of the Indian Constitution. Article 19, Clause 1, Subclause B guarantees freedom of assembly and the right to form association or union. However, these rights are subject to reasonable restrictions under Article 19, Clause 3, in the interest of sovereignty and integrity of India, public order and morality. Article 22 of the Indian Constitution. The article protects individuals from arbitrary arrest and detention, but also allows the government to detain individuals in the interest of national security and public order under preventive detention laws. Article 355 of the Indian Constitution. The provision gives the central government the authority to ensure that the government of each state is carried out in accordance with the provisions of the Constitution. If public order or national security is threatened, Article 355 allows the President to take necessary actions, including imposing President's rule under Article 356. Article 356, President's rules. If a state's governance is impaired, or if there is a breakdown of public order, the President can take over the administration of the state and dissolve the state government under Article 356, a mechanism used to maintain public order in times of crisis. Conclusion. National security is about protecting a nation's integrity, sovereignty and citizens from external and internal threats, including military aggression, terrorism and cyber attacks. Public order, on the other hand, focuses on maintaining law and peace within the country, ensuring that citizens are safe from disturbances or criminal activity. Both concepts are integral to a country's governance and require a balance between protecting national interests and ensuring the freedom of individuals. In India, while the public order is largely managed at the state level, national security often involves central agencies and forces, highlighting the importance of the coordination between the central and the state government for maintaining both security and public peace. Constitutional validity of emergency detention in England and India, its effect on civil and constitutional liberties. Emergency detention refers to the detention of individuals during times of national emergency or threats to national security. Such detention is usually carried out under the laws of preventive detention, which allow authorities to detain individuals without trial to prevent them from committing offences or posing a threat to national security. The constitutional validity and effect on civil liberties of such detention are different in England and India, primarily due to the contrasting legal frameworks and system of governance in both countries. Emergency detention in England. Constitutional framework and legal basis. In the United Kingdom, emergency detention is not explicitly provided for in a single written constitution as the UK allows an unwritten constitution based on statutes, common law and conventions. The ability to detain individuals during a national emergency is derived from laws like the Emergency Powers Act and the Terrorism Act. Some key provisions related to detention in emergency situations include the Emergency Powers Act 1920. This act allows the government to make emergency regulations, including the power to detain individuals during a time of war or national crisis. The Terrorism Act 2000. This act allows for the detention of individuals suspected of terrorism-related activities without trial for a specified period up to 14 days. This was later expanded to 28 days, though the provisions have been periodically reviewed and amended. Anti-Terrorism Crime and Security Act 2001 allowed the indefinite detention of foreign nationals suspected of terrorism. This provision was later unconstitutional by the House of Lords in 2004. Constitutional validity and judicial oversight. Parliamentary supremacy. In the UK, the concept of parliamentary sovereignty means that Parliament can pass laws that override other legal principles, including constitutional rights. However, this has been tempered by judicial review, especially after the Human Rights Act 1998, which incorporates the European Convention on Human Rights (ECHR) into UK law. Judicial oversight. Courts in the UK have traditionally exercised judicial oversight in cases involving emergency detention to ensure that it complies with fundamental human rights. For instance, the detention provisions under the Terrorism Act 2000 were challenged and limited by the courts in cases like A and others versus Secretary of State for the Home Department 2004, where the House of Lords held that indefinite detention of non-national without trial violate the ECHR. European Convention on Human Rights ECHR. The UK is bound by the ECHR, and any law or detention order that violates the rights guaranteed by the convention can be challenged in court. For example, detention without trial in violating of the right to a fair trial under Article 6 of the ECHR can be declared unconstitutional. Effects on civil liberties. Emergency detention in the UK affects the civil liberties of individuals, particularly the right to liberty and security, Article 5 of the ECHR. While the UK has implemented safeguards such as judicial review and limits on detention periods, emergency detention still poses a significant risk to individual rights. Detention without trial can infringe on personal freedom and the right to fair hearing. Racial profiling and discriminatory detention have been concerns, particularly regarding the detention of non-national under anti-terrorism laws. Prolonged detention without trial can erode trust in the justice system and lead to human rights abuses. Emergency detention in India. Constitutional framework and legal basis. In India, emergency detention is governed by preventive detention laws, which enables authority to detain individuals without trial during times of national emergency. These laws are laid out in the Indian Constitution and specific Prevention Detention Acts such as the National Security Act NSA 1980, the Prevention of Terrorism Act (POTA) 2002, now repealed, and the Unlawful Activities Prevention Act (UAPA). Key provisions in India are related to emergency detention. Article 22 of the Indian Constitution provides protection against preventive detention. However, preventive detention laws allow for detaining individuals without trial for up to 3 months, and in certain cases, the detention can extend up to 1 year. During a national emergency, Article 352, this period can be extended further. The National Security Act NSA 1980, this law empowers the government to detain individuals suspected of threatening national security for up to 12 months without trial. The Unlawful Activities Prevention Act (UAPA). This act allows for preventive detention and has provisions that allow the government to detain individuals without trial if they are suspected to engage in activities related to terrorism or secession. Constitutional validity and judicial oversight. Preventive detention laws. While preventive detention in constitutionality valid in India, it is subject to certain safeguards. The Constitution Article 22 provides a mechanism for review of such detention orders by an advisory board. However, the effectiveness of this mechanism is often debated as the board's decisions are not binding on the government. Judicial review. The judiciary plays a significant role in reviewing the legality of detention orders. Courts can examine whether the detention order was made in good faith and whether the individual's rights were violated. However, the scope of judicial review is limited when a national emergency is declared and the government can detain individuals without sufficient legal scrutiny. National emergency. During a national emergency, the constitutional protections under Article 22 can be suspended, allowing for broader detention power without judicial review. This was seen during the emergency of 1975 to 77, when preventive detention was widely used to suppress political opposition. Effects on civil liberties. Emergency detention in India has a direct impact on civil liberties, especially the right to personal liberty, Article 21 of the Constitution, which guarantees the right to life and personal liberty. The effects of emergency detention on civil liberties are as follows. Right to a fair trial. Preventive detention without trial encourages an individual's right to a fair trial. Detaining individuals without judicial oversight for extended periods undermines the principles of justice. Potential of misuse. The broad powers granted under laws like the NSA and UAPA can relate to the arbitrary detentions of individuals, especially political opponents, journalists, or activists who are critical of government. Impact on freedom of expression. Emergency detention laws are sometimes used to stifle dissent, particularly during period of political unrest or national security threats. Harassment and torture. In some cases, detainees under preventive detention may face physical abuse or mental harassment, particularly when detained in unsanctioned conditions. Comparison of emergency detention in England and India. England, India. Legal framework in England, unwritten constitution governed by laws like the Emergency Powers Act, Terrorism Act. And legal framework in India, unwritten constitution governed by laws like NSA, UFTA, and Preventive Detention Provisions in Article 22. And constitutional validity in England, parliamentary sovereignty but subject to the European Convention of Human Rights. And in India, valid under Article 22 with safeguards but subject to suspension during a national emergency. Judicial oversight in England, judicial review available, especially post 1998 Human Rights Act. And in India, judicial review possible but limited during national emergency. Detention without trial, possible for up to 28 days. Terrorism Act, indefinite for foreign nationals pre-2004. Possible for up to 12 months. NSA longer during national emergency. Impact on civil liberties, affects right to liberty and security issues of racial conflict. Affect right to liberty, freedom of speech, potential for misuse. Effect on political dissent. In England, can suppress terrorism-related dissent but not political speech. In India, can suppress political dissent, criticism of the government, and activism. Conclusion. Both England and India permit emergency detention in specific circumstances such as national security threats or public disorder. However, the constitutional validity and impact on civil liberties differ due to their contrasting legal system and constitutional frameworks. In England, emergency detention is subject to judicial review and must comply with human rights standards. Although there is still a risk of infringement on civil liberties, particularly in counter-terrorism laws. In India, while preventive detention is constitutionally valid, it poses a greater risk to civil liberties due to broader powers granted to the government, especially during national emergencies and limited judicial scrutiny during such periods. In both countries, emergency detention should ideally be used only in exceptional circumstances and with stringent safeguards to protect individual rights and prevent misuse by authorities. Now, Unit 2nd. Indian Constitution, Preventive and Safeguards Provisions. The Indian Constitution contains provisions that deal with preventive detention and the safeguards to protect individual rights against arbitrary actions by the state. These provisions are found primarily in Article 22, which governs preventive detention laws and various other articles related to fundamental rights. Below is a detailed overview of the preventive detention provisions and the safeguards provided by the Constitution of India. Preventive detention under Article 22. Concept of preventive detention. Preventive detention refers to the detention of an individual without trial based on the belief that the person may commit an offense or pose a threat to national security, public order, or the sovereignty of the nation. The idea is to prevent an individual from engaging in activities that may harm the state or public peace, rather than pushing them for an offense they have already committed. Article 22. Safeguards against preventive detention. Article 22 of the Indian Constitution provides safeguards against arbitrary preventive detention. However, it also allows for preventive detention under certain conditions, especially during times of national emergency. Key provisions of Article 22 include right to be informed. Article 22 Clause 8 states that no person shall be arrested and detained without being informed of the reasons for their arrests and detention as soon as possible. Our right to consult a legal practitioner. Article 22 Clause 1 also guarantees that the detained person has the right to consult a legal practitioner to defend themselves unless such consultation is prevented by a law that authorizes preventive detention. Maximum period of detention without trial. Article 22 Clause 3 allows for preventive detention but specifies a maximum period of 3 months. However, this period can be extended by the advisory board set up by the government, which reviews the detention after 3 months. Detention without trial. The government can detain an individual without trial under preventive detention laws for a period up to 3 months. For detention beyond 3 months, can advisory board comprising judges must approve the detention. Okay, preventive detention during national emergency. Article 22 Clause 7 states that the rights of a person to be informed of reason for detention and to consult a legal practitioner can be suspended during a national emergency declared under Article 352. This means that during a national emergency, and government has the power to detain individuals without judicial oversight or consultation. Laws relating to preventive detention. India has enacted several preventive detention laws that operate under the provisions of Article 22, includes National Security Act NSA 1980. This law empowers the government to detain individuals without trial for a period of up to 12 months or for reasons related to national security, public order, or the maintenance of essential services. The Unlawful Activities Prevention Act UAPA 1967. UAPA empowers authorities to detain individuals suspected of being involved in terrorism or activities prejudicial to the integrity and sovereignty of India. Prevention of Terrorism Act quota 2002. Though repealed in 2004, both allowed preventive detention for terrorism-related activities. Safeguards against preventive detention. Although the Constitution allows for preventive detention, it also provides several safeguards to ensure that this power is not misused by the government. Advisory Board Article 22 Clause 4 to 22 Clause 7. Article 22 Clause 4 to 22 Clause 7 specify that preventive detention cannot exceed 3 months unless an advisory board of judges approves the continued detention. The advisory board is appointed by the government and comprises judges of the High Court. The detained individual or their representative can present arguments before the board. The board rule is to ensure that the detention is based on reasonable grounds, and it provides a check on arbitrary detention. Article 22 Clause 5 mandates that the government must provide the detained individual with an opportunity to make a representation against their detention before the advisory board. Detention review by courts. Judicial oversight. While preventive detention laws provide for an advisory board, they also follow for judicial review or detention orders. If an individual believes that detention is unlawful, they can approach the courts to challenge the order. Right to challenge detention. Courts can scrutinize whether the detention order was issued in accordance with the law and whether there were valid grounds for detention. However, this review is subject to the nature of laws involved, particularly in cases of national emergency. Limitation of review during a national emergency. If a national emergency is declared under Article 352, the right to challenge preventive detention can be suspended, reducing judicial scrutiny. Maximum detention period. The maximum period of detention without trial is 3 months under normal circumstances. The government can extend this period only if the advisory board approves it, which ensures that detention cannot be indefinite and requires an independent review. In cases where the detention is extended beyond 3 months, the detaining authority must justify the detention before the advisory board and may be required to release the detained person if the board does not find sufficient grounds. Right to make up representation. Article 22 Clause 5. Article 22 Clause 5 provides the detained individual the right to make a representation against their detention. This right is a safeguard against arbitrary detention. The authorities are required to place the reason for the detention before an independent advisory board or tribunal. This ensures a balance between the need for preventive actions and the protection of individual rights. Preventive or detention during national emergency. Under Article 352, a national emergency can be declared in India in cases of war, external aggression, or armed rebellion. The powers of the government become much broader during such an emergency. Suspension of fundamental rights. During a national emergency, the rights under Article 19, freedom of speech, assembly, movement, etc. can be suspended, and the provisions of Article 22 can be bypassed, allowing for detention without trial and without providing the detained individual the right to challenge the detention in court. Extension of detention period. During an emergency, detention may be extended beyond the usual 3 month limit, and the safeguards providing in normal circumstances may not apply. Article 359 allows the President to suspend the enforcement of fundamental rights except Article 20, protection against retroactive criminal laws, and Article 21, protection of the life and personal liberty during national emergency. Conclusion. Preventive detention laws in India are constitutionally valid but subject to strict safeguards under Article 22 of the Constitution. These safeguards include the right to be informed of the reasons for detention, the right to consult a legal practitioner, the right to be reviewed by an advisory board, and the right to challenge detention in court. However, during a national emergency, many of these safeguards can be suspended or curtailed, providing the government with broader power of detention without judicial oversight. The purpose of preventive detention is to maintain national security and public order, but it also essential to ensure that the powers are exercised judicially and within constitutional bounds to protect the civil liberties of citizens. The Constitution's framework strikes a balance between security concerns and individual freedom by providing safeguards and against arbitrary detentions. Constitution of special courts, their powers and procedures. Special courts in India are constituted to handle specific types of cases that require specialized knowledge or are of particular importance to the country's governance and administration of justice. These courts are established under different provisions of the Constitution of India and legislative enactments to deal with particular kinds of offences or disputes. The powers and procedures of these courts are outlined in relevant laws, with a special emphasis on the judicial powers conferred upon them to handle cases expeditiously and with appropriate expertise. Constitution of Special Courts. The Constitution of India does not directly provide for special courts. However, various statutory laws enacted by Parliament provide for the establishment of social courts to deal with certain types of cases, such as cases related to terrorism, corruption, financial fraud, and offences affecting national security. These courts are often created with the objective of ensuring quicker trials and effective justice. Here are some important laws under which special courts are constituted. National Investigation Agency (NIA) courts. The National Investigation Agency (NIA) was established under the NIA Act 2008 to investigate and prosecute offences related to national security, including terrorism. The NIA Act 2008 empowers the government to set up special courts to deal with offences investigated by the NIA. Prevention of Corruption Act 1988 Special Courts. Under the Prevention of Corruption Act 1988, special courts are constituted to deal with cases of corruption, bribery, and abuse of power by public officials. These courts expedite trials of public servants accused of corruption. Special courts under the Lawful Activities Prevention Act UAPA 1967. The UAPA provides for the establishment of special courts to try cases related to terrorist activities. These courts have jurisdiction to handle offences related to unlawful activities, terrorism, and activities detrimental to national security. Special courts under the Terrorist and Disruptive Activities Prevention Act (TADA). Although TADA was repealed in 1995, special courts were established under it to try cases related to terrorism. It empowered the government to create special courts with enhanced power for dealing with such offences. Fast-track courts. The fast-track court system was introduced in India to expedite the trial of cases, particularly in matters of heinous crimes like sexual offences, corruption, and crimes against women and children. Courts under the Companies Act 2013. Under the Companies Act 2013, certain matters related to company offences such as fraud, financial irregularities, and mismanagement are referred to special courts. POCSO Protection of Children from Sexual Offences Act 2012. The POCSO Act mandates the establishment of special courts for the speedy trials of cases related to child sexual abuse. Powers of special courts. Special courts, although constituted under various laws, have similar power to those of ordinary courts with the same additional powers to all procedures designed to deal with the specialized cases. These powers include judicial powers. Special courts have the authority to try cases and pass judgment on the matters before them. They have criminal jurisdiction the matters related to their specific area of focus, such as terrorism, corruption, or child sexual offences. Power to award special sentences. Special courts can impose sentences specific to the offences they deal with, including capital punishment in cases of terrorism or life imprisonment in cases of corruption for financial crimes. Power to intercept communications and evidence. Special courts, particularly under the UAPA and NIA Act, may have enhanced power to permit the interceptions of communications and obtain evidence from intelligence agencies and other law enforcement bodies. Power to issue special orders. Special courts may issue special orders for the protection of witnesses or victims, especially in sensitive cases such as terrorism, sexual offences, or corruption. Power to direct government agencies for investigations. Special courts can direct specialized investigation agencies like the CBI, NIA, or ED Enforcement Directorate to investigate offences that are under their jurisdiction. Procedure of special courts. The procedure followed in special courts can differ from regular courts, particularly when it comes to the speed of proceedings, admissibility of evidence, or the nature of hearings. Below are some of the key aspects of the procedure followed in special courts. Expedited proceedings. One of the primary of special courts to expedite the trial process. Therefore, these courts are often set up with specific timelines to ensure quick adjudication of cases. Trial procedure in special courts. The trial procedure may involve enhanced surveillance, witness protection, and special provisions for presenting sensitive evidence, such as classified or confidential materials related to national security or corruption cases. Pre-trial detention. In cases under UAP and IA Act and TADA, individuals accused of terrorism or related offense can be detained without trial for a specified period. The procedure ensures a quick review of such detentions. Special procedures for sensitive cases. For cases involving terrorism or national security, special courts may allow for in-camera proceedings, closed-door hearings, where the public and media are excluded from the courtroom. Evidence and testimony. Special courts often rely on specialized evidence, including intercepted communications, forensic reports, and expert testimony. These courts may have the power to admit evidence obtained through unconventional methods such as electronic surveillance. Okay. Appeal and review. Decisions of special courts can generally be appealed in the High Court or Supreme Court, depending on the nature of the case and the jurisdiction of special courts. For example, judgments in terrorism-related cases under the UAP or NIA Act can be appealed to the High Court. Specific provisions for protection of victims and witnesses. In case of sexual offenses, terrorism, and organized crime, special courts often make provisions for witnesses' protection, and in some instances, victims or witnesses may testify anonymously or behind closed doors for their safety. Conclusion. Special courts in India play a crucial role in addressing specific types of offenses or legal matters that requires expertise or urgent resolution. These courts are established under different statutes and dealing with cases of terrorism, corruption, financial crimes, and sexual offenses. The power of special courts include handling complex cases with special procedures designed to expedite justice, such as enhanced power of detention, specialized investigations, and in some cases, closed hearings. Their procedures are also designed to provide a fair trial while ensuring the safety of witnesses and the protection of national security.